For those seeking permanent settlement in the UK, to primary visa pathways can eventually lead to indefinite leave to remain ILR, the 5-year and the 10-year routes. Let's explore what each involves and the key requirements applicants must meet. If you hold visas such as the skilled worker, global talent, or UK ancestry visa, you may qualify for ILR after 5 years of lawful residence. However, certain essential conditions must be fulfilled. Continuous lawful residence: you must have legally lived in the UK without major interruptions for 5 consecutive years on an eligible visa. Restricted absences: your time spent outside the UK must not exceed 180 days in any rolling 12-month period. This includes all travel, whether for holidays, family visits, or professional reasons. Life in the UK and language proficiency: applicants aged 18 to 65 must pass the Life in the UK test and demonstrate English language skills. This typically means passing a secure English language test (SELT) at B1 level or holding a degree taught in English. Visa-specific conditions: you must continue to meet the terms of your current visa. For instance, skilled worker visa holders are usually required to earn a minimum qualifying salary at the time of ILR application. Good character requirement: a clean record is vital. Any breach of immigration laws or irrelevant criminal record may jeopardize your eligibility. If you arrived in the UK through employer sponsorship or joined a British partner on a spouse visa, you are likely on the direct 5-year ILR track. As long as you maintain your visa conditions and monitor your absences, you can apply for settlement once the 5 years are complete. But what if your visa journey has been more diverse? That's where the 10-year-long residence route becomes crucial. This option is designed for individuals who've accumulated a full decade of continuous lawful stay in the UK, even across multiple visa categories. For example, your immigration timeline might include 3 years as a student, followed by 2 years on a graduate visa, and then 5 years under a skilled worker visa. Alone, none of these categories qualify you for ILR in 5 years, but collectively, they can unlock eligibility under the 10-year route. The main criteria align closely with the 5-year path. 10 years of uninterrupted lawful residence is useful. Completion of the Life in the UK test: proof of English language competence, fulfilled of the good character standard. There have been significant updates that applicants need to take seriously. Revised absence rules: the previous policy allowed up to 548 days of absence over 10 years, with no single trip exceeding 184 days. As of April 11, 2024, a stricter rule applies: no more than 180 days outside the UK in any rolling 12-month period. If your 10-year residence spans this cutoff, both sets of rules may apply. 12-month holding rule: applicants must now have held their current visa for at least 12 months before submitting an ILR application. This only affects those granted visas on or after April 11, 2024. This pathway is particularly valuable for individuals who have moved between different visa types, such as students who later transition to work visas. For many, the long residence route is a flexible and viable road to settlement. As changes to UK immigration policies unfold, it's more crucial than ever to monitor your visa status, particularly around absence limits and the new 12-month visa holding rule. While these updates have already introduced some complexity, even more significant changes may be on the horizon. On May 12, 2025, the UK government released an immigration white paper outlining sweeping proposals that, if enacted, would reshape the landscape of settlement in the country. Let's be absolutely clear: these are proposals, not enacted law. The government has stated that a consultation process will take place before any changes are implemented. At the heart of these proposals is a bold suggestion to double the qualifying period for indefinite leave to remain ILR, from 5 years to 10 years for the majority of visa routes. The reasoning? The government aims to introduce what it calls an earned settlement framework, emphasizing that permanent residency should come as a result of long-term contributions to the UK's economy and society. There is a mention of a possible expedited route for those who demonstrate exceptional contributions, perhaps through a points-based system. But as of now, the details around this potential fast-track option remain vague. Understandably, this has triggered a wave of uncertainty. Let's tackle two of the biggest questions. This is, without a doubt, the most pressing concern, and, at the moment, we simply don't have a definitive answer. The white paper doesn't clarify whether the proposed 10-year requirement would apply retroactively to those currently living in the UK under the existing 5-year ILR route. The government has mentioned the possibility of transitional arrangements to safeguard those already in the system, but no specific guidance has been provided. For thousands of people building their future in the UK based on current rules, this ambiguity is understandably a source of stress and concern. According to the white paper, most work-related visa routes, including the commonly used skilled worker visa, would likely fall under the new 10-year rule should it be adopted. However, there is some reassurance for families. The government has explicitly stated that the 5-year ILR route for family members of British citizens, such as spouses and partners, will remain unchanged. As for other visas like the Hong Kong B&O, it's unclear how, or if, they would be affected. If passed into law, these proposals would represent one of the most significant overhauls of the UK's settlement framework in recent years. Depending on your current immigration journey, your situation likely falls into one of three broad categories. If you are currently residing in the UK on a visa like a skilled worker or spouse visa routes that lead directly to ILR after 5 years, your roadmap remains unchanged for now. Your goal is still to complete your 5-year term, meet all applicable requirements, and apply for ILR. That said, you must stay informed. If the proposed reforms are adopted, understanding whether transitional protections apply to you will be absolutely essential. Perhaps your immigration history includes a series of different lawful visas. In that case, you're most likely following the 10-year lawful residence path. Your priority should be to maintain continuous lawful presence. Calculate your absences carefully, especially under the new rules introduced in April 2024, and ensure that you meet the 12-month visa holding condition if it applies to your current visa. If you've only recently entered the UK on a work visa or are planning your move, then these proposals could directly affect you. It's quite possible that your path to ILR may now involve a 10-year waiting period rather than 5. That's a substantial change, one that could significantly alter your long-term planning and career goals. UK immigration rules are known for their complexity, and with potential reforms underway, navigating them has become even more challenging. We hope this update has brought you greater clarity on the current ILR landscape and the proposals that could shape the future. As the situation develops, we'll continue to provide timely updates. If you found this explanation useful, be sure to like the video, subscribe to the channel, and tap the notification bell so you're always informed when new information becomes available. And feel free to share your general questions in the comments. We'll do our best to help. Thanks for watching, and we wish you all the best on your journey towards settlement in the UK.